we're gonna go ahead and get started. So, of course, this is our Georgia Divorce and Custody virtual workshop. And again, like I said, I'm attorney Janice Alfred. I'm the one hosting today. This is for educational purposes only, and it is not legal advice at all. Legal advice will be reserved for you talking privately with your attorney, and them giving you advice on how to move forward, or what steps to take in your case. So this is this is our firm, South Atlanta Family Law. This is one of our previous clients who left us a review. He's actually another attorney who hired us to do a modification for him. And this is the review that he left for us. He says, South Atlanta Family Law was there for me. They handled my custody action extremely quickly and professionally. I officially have full custody of my son now. With him, it was a really quick process. We were able to get him in and out and done in actually under a month. Okay. And so today we're going to be discussing the divorce process in Georgia, some basics of custody and child support, property and asset division, legal preparation tips, and then we have the Q&A at the end. I'm going to try to rush through this so that we have more time for questions. So just bear with me a little bit. So again, I'm attorney Alfred, and the goal of this whole workshop is to give you some clarity and confidence to make the right choices for yourself and your family. So we're going to break down the process and give you some practical steps to make sure that you leave with a better understanding of your options, and then have a stronger sense of how to move forward. So again, here's another quote: the more informed you are, the more control you have in shaping your life, pretty much. So the overview of the divorce in the state of Georgia. All right. So most cases have a clear framework, but every case is unique. So no case is going to be exactly the same. So if you understand the basics, that can help you prepare and avoid any unnecessary surprises along the way. So key things to know: in order for you to file a divorce in the state of Georgia, at least one of the spouses need to have resided in the state for more than 6 months before filing. So if one person moved from New York and they've only been in the state of Georgia for 2 months, and the other party's in New York, a divorce cannot be filed here. The divorce will have to be filed in New York. And if you live in the state and your spouse lived in the state and your spouse moved out, you can still file in the state. And if the party has not left for more than 6 months, you can file here and be able to address all of the issues. But once the person has been gone from the state for more than 6 months, only certain matters can actually be resolved. For example, if the children is with the other spouse, and the children have lived, say for example, the children have lived out of the state for more than a year, most likely they would not want to resolve the custody part in the state. You have to resolve that part in the other state, but you can still get a divorce here without actually addressing the issues. Sometimes it makes more sense for you to just file in the other states, so that way you can address everything, to keep everything in one place and to keep your costs down. But you can still get a divorce here whether your spouse lives in the state or not. There are so many different grounds for divorce, but the most common one is that the marriage is irrevocably broken. So that one is what they call a no-fault divorce. You can pretty much just say today to your spouse, I'm out, and then file for divorce tomorrow. There's no requirement that you have to be separated for any length of time in the state of Georgia. You can make up your decision today and file your divorce the same day or the next day. And then there's the fault-based ones are obviously the adultery, cruelty, abandonment, substance abuse, and there are some other things that we're just not going to get into. Um, and what people fail to realize is that most of the divorces actually resolved through the parties. The parties go into mediation, or the parties resolving the case amongst themselves or with the attorneys. Only certain number of cases require actual trials. And to be honest with you, the judges always prefer that you guys resolve your case on your own rather than bringing your issues before them and them having to make decisions that will affect your life and the life of your family. So it's always better to try to come to a resolution, However, if y'all cannot do that, then the courts will be able to make that decision for you. And then most of the times, you're not going to be happy. Nobody's going to be happy because there are going to be some things that you like, and then some things that you don't like. Same thing with your spouse. Okay. Um, and these are some examples. I don't need to really go into that. I think I kind of gave some examples already. um the steps in the process. So of course, somebody has to initiate the process by filing the petition. Now there are some exceptions. There's such a thing called an uncontested divorce. At our firm, how we handle them is one party comes to us and they tell us what the parties have agreed to, and the parties have to be talking, and they have to be amicable, and and able to resolve their own issues, because you'll have to tell us what you guys agreed to, and then we put all the paperwork together for you. And after everybody files, then we file the petition. In situations like that, we don't even have to go to court for the most part. There are some counties that may require hearing, but for the most part, most counties will just sign off on your order without a hearing once all the documents have been filed, signed and filed with the court. So again, if it's a contested case, the first step is to actually file the petition. In some counties, they do allow temporary hearings for things like maybe the spouse left and left the mom without any money to take care of the children, or you have issues where maybe the parties are not getting along and one wants the other party to move out. So the courts may allow the parties to have a temporary hearing while the case is pending. I'm going to be honest, Henry County does not really allow that. Henry County most requires that the parties go to mediation first before they can get a temporary hearing. Now there is another step that you have to, if you can show that your issue is an emergency, you can file what's called an emergency petition, and the court has to determine if they find your situation to be an emergency, and then give you a hearing. So they don't have a lot of time that they can allocate to those kinds of cases. So they are very, 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 very particular about what an emergency is, when they determine who gets to have an emergency hearing and who doesn't. Okay. So during so you can ask for a temporary hearing in some counties again, but Henry County is not one of those counties that will just willingly do that. The next step after that is discovery. So discovery is the process where the parties ask each party to answer questions and then provide documents. So, say for example, you're a stay at home, your husband is the one who controls all the finances. You have no idea what's in the bank accounts, you have no idea what the assets are. It is so important for you to serve discovery on the other side, to ask them to produce the financial documents so that you can be aware, fully aware of what the finances are, so that you can make an informed decision. We like to have discovery done before mediation, because then you want to go into mediation knowing everything that you need to know, knowing what all the assets are, knowing what all the issues are, so that you can make an informed decision at mediation. So again, after discovery, the next step is the mediation, where you meet with a third party. Some of them are attorneys and some of them are not. There are a few that Henry County will appoint. I'm sorry, will not appoint, but they will assign to your case. So like I said, some attorneys, some are not. So, but most of them are very, very familiar with the judges and how the judges rule, and they're trained. They have to actually go through classes and get training on how to mediate cases. So most of the times the cases do resolve in mediation. And then typically you come out with a full agreement, but there have been some instances where we come out with a partial agreement where certain things were resolved and certain things were not. And so we resolved the issues, some of the issues that we could resolve, and then we left the other parts for the judge to decide at a trial. And then there's some mediations where there's nothing has been resolved, and so that case obviously has to go and they have to have a full-blown trial with a judge, and the judge will have to decide the issues. The next step obviously is the trial. If there's no agreement, you have to schedule the case for a final. Sometimes the judge will actually be the one to schedule it. Sometimes the parties schedule it. So either way, the courts are they're gonna have you resolve the case whether by agreement or whether through the judge having to decide. Now there are some situations where people ask for jury trials, but if it's anything to do with children, only a judge can decide that. But things like property division and alimony, a jury can actually decide those things. Jury trials in domestic cases are rare. Um, Nobody likes them. Judges don't like them either. But it has happened, especially for the really high asset cases. In the end of a divorce case, you will get what's called a final decree, and the final decree is it could be a long form final decree where everything is laid out. It could be a final decree that pretty much incorporates the other things that we're going to talk about, which is the settlement agreement that deals with the property, the parenting plan that deals with the children, but the final decree is what you get at the end of your case that tells you that you're legally separated from the person, free to do whatever you want, live wherever you want, and be a free person. I don't know if I just said that, and be without a spouse. Okay. Um, so myth, and I think I addressed that before. Every divorce has to go to court. That is not always the case. Most parties do resolve their case sometimes before it even gets filed, the uncontested divorces, or in mediation, and sometimes even after mediation. And sometimes we actually resolve cases right after the filing before we even do mediation. But that is not something that happens very often. Fun fact: 11.2% of all adults in Georgia are divorced, slightly higher than the natural average of 10.8. Ask me why. I have no idea, but apparently that is the stat. So the next topic is going to be custody and child support. And the quote that we wanted to obviously highlight is, custody isn't about winning or losing. It's about creating a stable, healthy future for your child. And that's kind of important because a lot of times, people use their children as a weapon against the other party. Both men and women will do it, and that is never really a good situation for the child. The child's always going to be the loser in a situation like that. um, Custody in the state of Georgia, when children are involved, obviously people are very emotional about their children, so it will make for a very emotional divorce. Um, but what the courts focus on is what is in the best interest of the child above everything else. They don't really care what you want. They don't really care what your husband or your wife wants. They just care about what is most important, what is in the best interest of the child. So things that the courts will look at, is things like who got them up and prepared them for school, who fed them, who took them to the doctor, who knows their teachers, who has meetings with the teachers, um, who will foster, that's important, who will foster a relationship with the other parent, right? That is very important because, like I said, there are sometimes, one parent does not do that and they actually weaponize the child against the other. So that is important to the judges. Now, legal custody, people get confused about this all the time. There are two different kinds of custody. One is legal and one is physical. Legal custody is who gets to make the dated, well, not a day-to-day, but the big decisions. Because when a child's in your custody, you get to make the day-to-day decisions. But who gets to make the big decisions? The big decisions that Georgia, thinks is important are education, of course, non-emergency health care, religious upbringing, and extracurricular activities. Those are the four things. Now, that is typically joint. So that means that the parties need to confer with each other to make a decision for their child that's in the best interest of their child. But if it's two of you and there's a disagreement, somebody has to be the tiebreaker. And so generally it's the person who has primary who is the tiebreaker. Now, there are also situations where, say for example, dad is the coach for the kids, and dad has signed them up for different activities and stuff. The court may allow dad to have final say so in extracurricular activities. um education. Mom is a teacher. The child goes to school where mom lives. That will typically go to whoever the primary custodian is, because where the child lives typically is where the child gets to go to school. Physical custody is, where the child lives primarily. And so obviously that has to be determined. And then you also have what's called secondary custody, and that's going to be what the other parent is going to have. Okay. So child support is obviously a sticky subject for a lot of people. The courts obviously believe that both parents need to be responsible for taking care of a child that they have created. The child support is supposed to cover all the basic things that the child needs. Um, and there are some extraordinary things that the courts will also consider. So, for example, the child um, was attending private school while the parties were together, right? And so now that they're getting a divorce, one parent may be like, "Well, I don't want to pay for child support anymore. I mean, I don't want to pay for private school anymore." The courts would consider that. Well, you weren't in private school while you were together, and so now why should things change? So the courts may very well make the parties split the cost of the private school. Things like childcare costs, daycare costs, aftercare, all of those things will be factored into the child support worksheet. And if the child has any special needs that where they require additional services that have to be paid for, and of course we'll also consider those things as well. Um, in Georgia, unlike some states where they just look at dad's income and they determine it's a percentage that they do, Georgia looks at both parties' income. So Georgia will put both mom's income and dad's income into a worksheet, and then the worksheet spits out for you, and then you put all the other numbers in there like medical expenses and childcare costs and all those things, and it will spit out what each party will be paying, depend on who has custody. So they will combine the income and then determine the amount that each party would have to pay, depending on who has custody. So for the most part, I would say child support is kind of really like the easiest thing to determine, because it really is just based on income, except when somebody's trying to hide income. For example, they own their own business and you can't tell what their actual income is because they don't get pay stubs. Their tax returns always show a loss. Those kinds of things make it a little bit more difficult to calculate child support. But for the most part, if you have a job, we can get your pay stubs, and we easily put the information in, and it will tell us what the child support obligation will be. Parenting plans. When kids are involved, that is really the most important thing that the parties can come up with. That is what sets out the legal custody, the physical custody, the visitation, who um who has tie breaking authority, um, and any other thing that you can think of. So, say for example, um, you know, you want to address things like, mom has to give me 30 days notice before she moves. Stuff like that gets placed in the parenting plan. Um, I do not want dad to drink alcohol while the children are in his custody. Things like that can go in the parenting plan. I do not want um, somebody of the opposite sex living in the home while my children are with the other party. Now I'm gonna say this about that. So um, it used to be acceptable to put that in agreements, and the judges could order it, but these are not acceptable things anymore unless the parties agree to it. So the courts will put in one of those clauses about no party of the opposite sex living in the home or staying in the home while children are there, but only if the parties agree to it. The courts cannot really order that anymore. Um, what it also does, it prevents, say for example, you are the person who has primary custody, and that means that you can never have a living significant other, so that pretty much hinders, people from being able to have relationships. And so the courts felt like that was not really, in the best interest of anybody. Okay. So I think I addressed all those things. So the holiday schedules, all of those things, transportation, where the exchange is gonna happen, all of those things, get placed in that parenting plan. And then the judge gets to sign this into an order. And this is one of the things that actually does get incorporated into the final order, as I mentioned earlier. Another myth: mothers always get custody in Georgia, and so I would say that maybe in the past that was closer to the truth, but it's not anymore. We now have a lot of younger judges, a lot of male judges and female judges. Some of them have been through divorce and stuff like that, so that's not really the rule anymore. They really just consider what is in the child's best interest. So if you have a case, you pretty much will have to show the court that if you have to actually go to court, you will have to show the judge that that the child living with you primarily is in the child's best interest, because you've been the one doing all these things for the child while you were together and even after you're separated. This says 90% of custody cases are resolved by agreement between parents, not by judge ruling, and that is true. That's in line with the whole divorce thing. Most of the cases are resolved through agreement between the parties and not having the judge decide. Now we're going to talk about property and assets division. So equitable division looks beyond numbers. It recognizes each spouse's sacrifices and contributions. What gets divided? So in a divorce, you have assets, you have liabilities. All those things get divided. So things like the homes, vehicles, second homes, retirement accounts, pensions, bank accounts, and then also the debts. The debts are also liabilities that need to be divided in a divorce as well. So, and I saw some questions that came in, and I think that may address some of these questions for you guys. But so marital properties, anything that was acquired during the marriage, regardless of whose name is on the title. Okay, so if a house was purchased during the marriage, husband's name is the only name on the deed and on the mortgage. That doesn't mean that wife doesn't get to claim an equitable portion of the home. Just because her name is on there doesn't mean she doesn't have rights to it, right? So as long as it was purchased during the marriage. Now, there is a caveat. So if it was purchased with, say, for example, you inherited $500,000 from your mom, and you purchased the house and it cost $5,000, and you've not paid a dime of your income to fix the house, to pay the mortgage, then that can be considered separate property. But if you purchase it with your income, your money, which is a marital asset, then it is considered marital, whether the other party's name is on there or not. Okay. Separate property. That's assets that were owned before the marriage, and anything that's like inheritance or gifts that was made to the spouse only. Now, I will also say this because we get these questions a lot. Sometimes people buy houses before they get married. Now, there are times where they bought it in anticipation of marriage. That's easier to determine that it is a marital asset because it was bought in anticipation of marriage. But there are times when people buy a house 5 years before they got married, before they even met their spouse, they got married. But they continue to pay down the mortgage with their income, which is marital. The spouse has contributed to making improvements to the home, right? So that spouse can actually make a claim to the house, even if they were not there when you bought it, because by you paying down the mortgage, you increase the equity, right? By them making improvements to the home, it increased the equity. So there is a calculation that can be done to determine what is marital and what isn't, and then the parties can either agree on splitting that, or the judge will have to decide, how they're gonna deal with that. Okay. Um, how division of property works in Georgia. So the courts will consider some things like the length of the marriage. So the longer you guys are married, the more likely you're able to get equitable share of the assets. And that also applies for a request for alimony as well, which is not part of the topic, but it is. The length of the marriage obviously is a determining factor in whether the court grants alimony or not. Contribution of a spouse, so both incomes, both of your income savings. Um, the homemaker, she would stay at home while you went to work. That doesn't mean that she doesn't get a share of the assets because the name is not on anything. Um, and then the ability for them to earn a stable income going forward. So these actually also apply to alimony as well. All these three things that I talked about. For alimony, you will look at length of marriage, um, your ability to be able to be employed. So the longer you stay out of the workforce, the less likely you're able to get job. Your age will also affect that. Um, the level of education. So if you skipped on going to college because you wanted to stay home and take care of children, all of these things would be considered. But then you also have to have the other spouse has to also have an ability to pay. So say for example, the spouse makes $2,000 a month, right? And you're separating, the spouse has to be able to live somewhere else. So the chances of you getting alimony is kind of slim because there really isn't much to give you. So obviously, the more money the other spouse makes, the more likely, you know, you are able to get alimony. Where am I? So I already addressed that, so I don't need to go through that. Um, Another fun fact in Georgia, about 60% of contested divorce in Georgia involve disputes over property division, making it one of the top reasons cases go to trial. And that is kind of true. So property division, and custody. They fight about custody a lot as well. But property division and alimony, I consider to be the number one reasons why people go actually have a trial with a judge. And like I said, those things can actually be resolved with a jury trial, if the party requests a jury trial instead of having the judge decide. So obviously, if you're going through a divorce, you have to prepare for it. um there are certain things that you can do beforehand to prepare. If you have decided that you wanted to get a divorce, um you probably need to start gathering all of the financial records, especially if you're the person who was not in the loop of what was going on. You don't know what the assets are. You don't know what's in the bank accounts. You don't know, you don't know any of those things. You might want to do some homework and try to start gathering that information, because there are times when we serve discovery on the other party and they don't produce anything, and then we have to file a motion to compel, or we have to go ahead and subpoena things. But if we don't know which bank account, who they bank with, we can't subpoena anything. So having that information is very, very helpful, not just to you, but to us in helping you figure out, how to resolve your case based on what the assets and liabilities are. Things like text messages, emails, conversations, you should keep those things, especially if it has to do with a parent keeping the child, keeping the child from from another party. Keep those emails, keep those messages, and give it to your lawyer so that your lawyer can have them in case we have to have a full blown trial with a judge. um Make sure you know what your account passwords and stuff are. Monitor your credit, know what debts are in your name, because it's important for us to know that what debts are in your name so that we can properly address it in the final paperwork. There have been times where people think that, oh, it's just in his name, and then they sign an agreement saying, where there's nothing that says he has a duty by a certain date to remove the account out of the other party's name. And so you just want to make sure that you know what's in your name so that we're able to address it and make sure that we put some information or some language in it that says when the other party has to do certain things so that they can remove your liability for the debt. um Track expenses, especially when it relates to children, child care costs and all those things, health insurance and all that stuff. All of those things are important. So just start gathering the stuff that you think are going to be important for your case, so that you can present it to your lawyer when they ask you to provide the information, so that we can help you. Um, and we can skip that one. All right. So Um, we do a lot of divorces. Divorces can be um they can be very emotional. Um, some parties can be angry. Um, and I can admit that we sometimes our clients sometimes are the difficult ones, and so we have to have that conversation with them. Obviously, you do not want to be the person that the judge is mad at when you go to court. So we always try to counsel our clients and make sure that they're not that person that the judge is going to hate and the judge is going to want to rule against because they're doing certain things that are harmful to the children, harmful to the marriage, and then harmful to how the assets are going to be divided. So wasting assets, spending the money on your paramour. Courts do not like those things where your children are not being taken care of. So do not be that guy. So we're always here to help you, set you on the right track, make sure you understand what your rights are, what you should be doing, what you should not be doing. And so it's very, very important for you to have someone on your side to help guide you through the process. Um, Also, you want to make sure that you have someone to, and even if like even if you do decide to do the divorce on your own, always try to make sure that somebody who is on your side reviews the settlement agreements and the documents for you, because what happens is once you sign it and the judge signs off on the order, right, you cannot go back. There's no backsies, right? You cannot go back. Now you can go back for modifications for certain things like custody, um and child support, but you cannot really go back on things that you agreed to, like how the property is divided, stuff like that. Now, if you can show fraud, maybe that person didn't disclose it, and it specifically says that you're supposed to disclose everything. There are ways that you can undo those things, but it's very, very difficult. So make sure before you sign documents, you have somebody review them for you. We do things. We do have a process called a strategy session where people would bring in their they don't want to hire us because they can't afford it or whatever, for whatever reason, or they're so close to resolving their case and they prepared all the documents. They bring it to us, or they got documents from the other side. They bring it to us. We do it. We set up 1 hour. We sometimes, most of the times that's not enough, but we can try. We try to do it in an hour, where we review the paperwork for you and tell you what we think about it, tell you what we think that's okay and what we think is not gonna benefit you or is gonna be harmful for you. Um, and so I think that I have gone through the presentation, and so now we're gonna open up to the Q&A segment of this. So again, I just want to say that this is for educational purposes only. Um, I'm not giving any legal advice because obviously I don't really know your issues in detail. You share what it is you want to share with us. You don't have to share details. And it could be a general question. So before we open it up, I am going to go through some questions that we received beforehand. I'm going to try to read them kind of quickly, and I think I already addressed most of them, but I'll read them quickly and try to answer them quickly so that we have more time for you guys to answer to ask your questions. So one of the questions I received was, can a husband who got caught at a hotel with a woman, um, can that evidence be used in a divorce case? Um, the husband entered the room with the mistress, same room number, and they stayed all night. Can the attorney request hotel footage? So yes, any evidence that you have regarding infidelity can be used and can be introduced if you actually have a hearing with a judge. It's not going to be important unless you actually go before a judge, and so the judge can determine whether infidelity was a part of the divorce, was the reason for the demise of the marriage. Whether we can subpoena hotel footage, we can try. um I don't know how long they keep footage um at the hotel. So depending on when you ask for it, if it's available, and we subpoena it, yeah, they will have to provide it. But most of the times those things get recorded over. So obviously, the faster you get it, you send a subpoena, the faster you can maybe you the more likely you're able to get that evidence. um and can money transfer receipts be used? Can bills being paid with the husband's bank card be used? All that, yes, all these things can be used. Now, I will say this too, um that some judges, they they don't think that you having a receipt is enough to show that there's infidelity. They Some of them require that you have some actual proof that there was infidelity. So videos, stuff like that of them actually in the act. I don't know why any judge would want to see that, but things like that are more obviously more credible than you showing a receipt of him buying dinner for someone. The other part of the question is, in Georgia, do you have to have children to keep the house or get alimony? If wife was his husband prior to the land purchase and property building, just dating prior to marriage, but helped with getting that foundation, everything set, we'd already been together. So, no, you don't. But that is kind of sticky. So if your husband, if you and him are on the mortgage, and um or he's the only one on the mortgage, and you want to keep the house, you have to have the ability to be able to remove his name off of it and buy him out, and then be able to pay the mortgage. If that is an impossibility, chances are the other spouse who has their name, who can afford it, might be able to keep the house, or the court may order that the house be sold. You have to have an ability to pay it and be able to assume it and buy him out, if you want to keep the home. Okay. So the next question is, I'm the owner of my home. My husband is not listed on the mortgage loan. How do I legally get someone out the home? So you cannot evict a spouse. So let's just be clear. You try to file an eviction, all he has to do is show you're married, and the eviction is going to be dismissed. So the only way you can get rid of him out, you can get him out the house, is to get the divorce. You get awarded the house, and then put a set date when he has to leave. The other part of that is, how do you get a protective order? That is another way that you can get the person to be removed from the house, but you have to show that there's been some violence or threat of violence, and that you're afraid of the person, or that there has been harassment. So you can get one either through violence, because of violence, or harassment. And what has to happen is, you have to go to the courthouse in the county where the person lives, and provide all your evidence to the person, the intake person, and then they will determine whether you have enough for them to grant you a TPO. If the court finds that you have enough, then they will serve it on the other person, and make the person leave the residence. And then you're gonna have to show up to court for the hearing, where they determine whether they're gonna grant it for. It can be 3 months, 6 months, or a year, but it's typically a year. In Henry County, you have to go to what's called Haven House, and they're the ones who start the process for you. And so we also handle TPOs too. People come to us after they've already filed it, or they come to us to defend it for them. What is the cost to file divorce? In which you have no debts. Okay, so um, I don't know if I want to go through cost here, but we have two different kinds of divorces. Obviously, like I mentioned, we have uncontested. That's cheaper. That's faster. We charge anywhere between 3,000 and 3,500, depending on whether they're children. Because if they're children, there's more documents that need to be prepared. If it's a contested case, we have a flat fee initial retainer, that not a flat fee. I'm sorry, an initial retainer that we charge. And if the more fighting you guys do, the more money you're gonna pay. The $6,500 is really just to get started. It sometimes will take you through the entire divorce, but that's very, very, very rare. When you have to do discovery, you have to do mediation, have to have trials, you most likely will have to replenish more than once. Next question. I've been separated from my wife for over 12 years. We have no assets, or our kids are grown. I just need someone to help me get a divorce. So we can help you with that. If you guys are talking, and you guys agree on all the terms, it can be an uncontested divorce. I already talked about that process. And if not, then we can help you file your contested divorce, and then either try to resolve it through mediation or between the attorneys, and if not, of course, go to a trial. Okay, we have a long one. Let's see. I have a question that may be a bit unusual. Okay. My spouse and I have been married for many years, but we reside in two separate residences, but only lately because I cannot deal with him. He currently lives in a house that we purchased together as a couple with the intention of sharing it together. Although he finds the mortgage singularly, so that is the same thing that I've already answered. The fact that he purchased the house and it's only his name does not mean it's not a marital asset, especially if you have contributed to paying down the mortgage or making improvements on there. So you can still make a claim to the home even if your name is not on the title. Natha, so at this point, I'm going to have you open it up for everybody to be able to ask questions. I don't know how to unmute people, so you're going to have to help me with that. Natha? Okay.
Hey y'all, so if you all want, if y'all have any questions of your own, you can raise your hand, and then we'll go that way, or you can type them in the chat box, whatever you all feel comfortable with. And if there's no questions, then we can conclude.
There are no questions? Y'all got to have some questions.
I have a question.
Okay.
I have a question. Can you hear me?
Okay, it's low. Let me see if it's my speaker. Okay, my speaker was low. Go ahead.
Okay, so this is my question. After 22 years of marriage, my husband has cheated numerous times, but on this last one, it produced a child. Does it now change the?
The proof? No, you say the proof? Yes, the child. Yes, obviously. Yeah, it will. It will change. Now, has he done a DNA test though?
Oh, he signed a birth certificate.
Oh, okay. Well, there's your proof. I mean, yeah, that's
But
proof
does it
enough.
now change because um our our divorce was supposed to be uncontested,
Mm,
but he hid the child, the affair. He
mm,
told our kids together that he thought the divorce would have gone through before I found out about the kid.
mm.
So now does it change because we're going through trying to change a set of motion. I was pretty much forced to sign the paperwork because he was like, sign the paperwork, you don't have the income for me to drag you through court. So I'm just like, oh my God, like he was constantly on me. So, I did it to be done and over with. I left the marital home because it was getting violent. Like every day he could just kept coming at me. So now that there's a baby in the picture, does it now change the dynamic of this divorce for real?
So my first question to you is where are you guys in the process? Have you so you said you signed documents, so have they been filed with the court and has the judge already signed the orders or no?
Has not signed the orders yet.
Did you?
I believe the last I heard was that she's pushing for us to go to mediation. And this is Henry County.
Okay. So you guys filed settlement documents, but the court is pushing for y'all to go to mediation?
Yes.
Why would they did y'all not resolve everything? Because normally when they have final
No, it
documents.
wasn't. No, it wasn't resolved at all. Again, I have recordings and proof of him,
No,
forcing
no,
me
no,
to.
no, no. But I understand what you're saying. But I'm saying, but you signed. What did you sign? Did you sign what's called a settlement agreement? Is that what you signed?
Yeah, I signed whatever it is he asked, whatever it is he put in the quote unquote uncontested divorce. It was
Mhm.
all him. I didn't get a equal part in saying anything. He just came home with papers like,
Yeah. So normally when the courts see a settlement agreement, now do you have minor children?
yes, we have one
And
more still left in the house.
did you guys sign a parenting plan?
No, I don't think
Ah,
so.
okay, so that's why. Okay, so typically when the courts see when we do uncontested divorces, right, we file everything. So the courts just pretty much wait to sign our documents. When pro se people do it, they don't do everything. So things are missing. So in your situation, they sent you guys. If everything was done, the court would have probably just signed off on it. But because y'all haven't resolved certain things, because everything needs to be resolved in the divorce,
Hmm.
that's why they sent you guys to mediation. So you can Since you already signed a settlement agreement, you can file what's called a motion to set aside agreement. um
Mhm.
you're gonna have to file that and let the court know that he misled you, uh
Mhm.
and that you no longer agree to the terms. Now let me just say
Mhm.
this though. So when there's infidelity, right, that does not mean that you get everything. And I'm not saying that that's what you think, but some people think that.
Mhm.
That doesn't
Mhm.
mean you get everything. When I asked the judges, I asked them at a we had a CLE, and I asked the Henry County judges, how do they treat infidelity? Like, what weight do they give to it? So most of them said that what they would do is they would split the assets 40-60. That's the most they would do. So it's not going to affect a whole lot.
Right.
You know what I'm saying? So
And that's not even the um it was just the intent, I believe, to deceive me and the whole situation. That's the part I think that it's
but
real.
here's my question to you. Why does it matter? Why does it matter that he deceived you? The only thing it should go to is whether I'm gonna get more of the assets. I mean, you guys are getting a divorce. You know what I'm saying? So you see what I'm saying? You need to prioritize what's important. So if you're trying to get more of the assets, then that's fine. Or if you're
No,
trying
I'm really
to,
trying to get I'm really my whole concern is really my son and his well-being because
okay, that's
um
the next thing I was gonna say. If you don't want your
that's
child around, yeah.
that's really what it is because he is living with dad for school purposes.
Oh,
But I am
how old is the
still
child?
huh?
How old is the child?
He is 16.
Oh, okay, so he's a big boy. Okay, so he okay.
Yeah. So
All right.
he's just finishing to stay out to finish up school. But
Mhm.
since all of this came out, his grades have tanked. Um, he's pretty much left to raise himself. So like I said, my concern is pretty much my child. I don't care about the assets, the house. I don't care about none of that. It is my son and
Yeah,
his well-being.
yeah, but how? But so now that his grades have tanked, what are you proposing? Are you proposing him not coming to live with you? Because y'all haven't even resolved that part yet.
Right. We haven't resolved that part at all.
So you still have room to resolve that part. So if you change your mind and you want to, but here you have to understand though that at 16 he can tell a judge where he wants to live. So if he wants to live
Right.
with
And
that,
and
most
he did
likely he's gonna stay there.
no. He
Yeah.
said he's already actually wrote it up on paper that I want to live with my mom in Henry County. The only problem I had was again, I'm the one who made the sacrifices financially. So I don't have the income to stay in Henry County.
Gotcha.
So that's where our and he didn't want to come back to Clayton County to go to school. So that's
Yeah.
why dad has him for right now.
So so
Thank you.
I mean, you guys are gonna have to work that out because he cannot stay here with you because you can afford it. He wants to stay here, and dad is the one who lives here, and he doesn't want to stay with dad. So you're gonna have to figure that out. You
And
know,
I wish we really could, but dad is very high conflict and very angry for whatever reason. I have no idea. I was just like, we don't have to
And
be
then
angry.
the
thank you,
child.
Chanel.
Okay,
Thank you.
hold on. Let me just say what this one thing. But the child is 16, so he can say where he wants to live, and
Right.
so that's not that difficult to resolve. He just has the judge will talk to him, and then the judge he'll say, "I want to live with my mom," and then the judge will say, "Okay,
Okay. Okay. All right. Then that's pretty much the base of my question.
okay." I'm sorry.
Thank
Go
you.
ahead.
Thank you. Thank you
Thank
so
you.
Brandy, go ahead. Thank you for your thank you.
Hello. Yes. Can you hear me?
I can hear you.
Okay. Yes, my question is, okay, in a divorce in which um do you my first question, do you have to have an actual reason to divorce?
So the fallback is always that it's irretrievably broken and there's no hope of reconciliation. That's the fallback. You don't have
Okay.
to put any of the bad things in there. You can just say that we don't get along anymore and we wanna go our separate ways.
Okay.
That's the fallback. That's what we mostly use in most of our divorces.
Okay. All right. My second question is, In a marriage, I guess it would be uncontested because we have no debt together. We don't. I have 3 children, but they're not his children from a previous marriage. So we have no assets together. And I would not want any alimony or anything. In those type cases, the marital, well, I have a home with in which when we got married, he came to live with me. So there's no division of property. Like I wouldn't lose my home, would I? Because he's not on the deed. I had the house prior to us getting married. How does that work?
So I don't know, maybe you came in a little bit later, but so even if the house was purchased before the marriage, they
Mm-hmm.
can make a claim. Now, not everybody knows this,
Mm-hmm.
but they can make a claim to whatever equity was earned while your income or their income paid down the mortgage, or if they made improvements to the home, you know, they can
Mm-hmm.
ask for the court to figure out what that marital portion is, and then
Mm-hmm.
ask for a share of it. So it's not
Really?
clear cut like you think. Hopefully he doesn't know that,
Mm-hmm.
'cause most people don't. Um, but yeah, he can make a claim. There's an actual formula that they use to determine what
Mm-hmm.
the marital portion is.
Okay, so that would be like, okay, we've been married maybe 7 years. So would it be from the time we got married to now?
Yes, yes, because your income that you use to pay down the mortgage is a marital asset. His income is a marital asset too. So
Okay.
yeah.
Okay.
All right.
Okay.
And then also, for it to be uncontested in our law firm,
Mhm.
um, it doesn't necessarily mean that both of you want a divorce and that there's nothing to divide. It's whether they're gonna sign the papers before we file it. You know,
Okay, that's what
because
determines
yeah,
contested
for
in.
for us, they
Uh-huh.
have to sign off on everything, and then we file everything with the court, and pretty much all we have to do is just wait for the judge to sign it. Now you can file the divorce, and then y'all can sign an agreement that just talks about general things like yo, everybody keeps their stuff, blah blah. You can do that too. But
Mhm.
for us in our law firm, the parties have to sign off on everything so that we don't have to go back and forth with the court or have to go to court.
Okay. Okay, one more part to that. So what are they signing off on that they would
So
have to agree?
so in an uncontested without children, there's
Mhm.
like 11 documents that we prepare.
Mhm.
In uncontested with children, it's about 13 to 14 documents.
Okay.
Petition, acknowledgement, verification, the
Mhm.
consent to try, the final decree, the motion, the
Mhm.
affidavits, the and the parenting plan if there's children, a child support worksheet, child support order, settlement agreement. I think I've listed almost everything. Yeah.
Okay. And then that makes me have one more question. Okay, so let's say I file for divorce, but they don't have to leave the home until the divorce is final. How does that work?
Y'all can agree on whatever you want. So y'all can agree that he moves out tomorrow. Y'all can agree on everything. But if y'all have to go to court, I'm sorry, if y'all cannot resolve that, then the judge is gonna have to decide. And so,
Mhm.
there's no requirement that he moves out until the judge says he has to move out. But y'all can resolve that issue. Y'all can agree on a date when he's gonna move.
Mhm.
Hmm.
Okay. Okay, that's the thing. That's I feel like if he served divorce papers, to me, that's going to create more feud in the home. You know, um, that tension that's going to be there and trying to live until the court date or court hearing.
Yeah. Oh, I know it all too well. So I always say to my clients, if you and your spouse are in a position where y'all can live together amicably,
Mhm.
then y'all can do it. But if you think that somebody's gonna put hands on somebody, and then somebody might go to jail,
Mhm.
then maybe you might want to be the one to leave if you can.
Mhm. Okay. Okay. All right. Thank you.
You're welcome.
Mhm.
Thank you, Chris. Go ahead.
Hi, yeah, thanks for doing
A
this.
face, a
A
face.
face, right? Yeah, yeah, I know. Um, probably not gonna get a lot of these on this call. But my name is Chris White, and I am executive director of Father Movement. I help dads get access and visitation to their children. And so I know we're talking about divorce here, but I'm assuming you guys do legitimation cases as well.
Yes, we do. That will be the next workshop. But yes, we do legitimations.
Ah, okay. And then I would love to get some more information on those workshops. And we're just always looking for attorneys that we can refer people to. So we have dads in need, and we also have some dads that are just kind of scared to participate in the legal system and gaining
Yeah,
access to their children.
or they don't even know. So that's why we're
Yeah,
trying to do the workshop. We're trying to go to schools and do these kinds of workshops. They don't even know that they don't have rights.
right, right. So yeah, I'd definitely like more information on that, and we'll look forward to talking with you guys about being able to refer people to you guys.
That'd be awesome. Thank you so much, Chris. Or Mr. White.
Absolutely, not a problem. Mhm.
So Nathal, get his information for the next one.
Will do. I'll be emailing you. And yeah, if anyone has any more questions, go ahead and raise your hands now. And if not, we'll close out with some final remarks.
Like, more questions. All right. So, oh, there's one. Hold on. Do you have? She asked a question about, do we handle cases in other counties? Is that the question? It kind of disappeared, kind of.
Yes, that is.
Yes,
Oh,
that was the question. Like I don't live in Herring County. Do you
oh,
all
that's
have?
fine. Yeah, that's fine. So we handle cases. Um, we just try not to go too far out for our attorneys. Um, so we handle Henry, Clayton, Rockdale, um, where else? Fulton, DeKalb, Cobb, Gwinnett. Um, well, so we don't do Paul. We will do Fayette, and we will do Spalding, and we will do, I think, either Butts or Bibb, whichever county is close to us. The not the one that Macon is in. The one I can't remember which one is Butts or Bibb, one of the two. So we
Mm,
do handle all of those areas.
okay.
So anything else? I see a Curtis Brown. He has a question. Mr. Brown.
Yeah, good evening. Um,
Evening,
how
sir.
soon after a divorce settlement can you challenge custody arrangement?
Okay, so if you agree or the court orders signs does the parenting plan and tells you what you're gonna do, you have 2 years, right? But it doesn't necessarily mean, so you have to show that there's been a change in circumstance where the parenting plan is no longer in the child's best interest. Now, there's sometimes 2 years is, something happens before the 2 years are up and you have to file. So, but it's typically 2 years, but you still have to show that there's been a change, something has changed where the current plan is not in the child's best interest anymore. Yeah, but we file modifications before the 2 years were up, but that is typically the general rule.
Yeah, I just have an issue with my ex, probably me being a little too emotional, but she bring it's a set plan. We're trying to follow the plan, but if she doesn't read it, she makes plans and she tell the child that she has plans, and now the child don't want to spend time with me because she's supposed to spend time with her mom who has primary custody. So
Okay.
that's what I'm asking.
So that sounds more like a contempt. Um, so because so what you probably would need to do is and I'm not one of those people who are like, okay, so she didn't do one, so file a contempt. You know, it keep track of all the things that she's doing, you know, and then file a contempt, not with just one thing. And the one incident is not enough. More than one incident, then fine. Now, what you have to do though is if it was your time and um don't just take her word for it and she tells you, well, you can't see your child. Go to wherever the exchange spot is, right? Because you have to make sure you show the court that you've actually went to the exchange spot and mom did not show up. You can record it, call the cops, get them to do a report for you. Obviously, you don't want to do that in front of the child, but if mom doesn't show up, get some record of you showing up and her not being there, and then you file your contempt. Now, the courts are not necessarily going to modify based on one contempt. So, say for example, the first one, the courts most likely will just say, okay, you need to give makeup time. Second time, the court may consider a change in custody. Third time, most of the times they will consider something like that if mom's actions are being egregious and mom is not following the court order. But keep track of all those things. Keep documentation of those things, and then of course bring it to an attorney to file. Or you can do it on your own. File it your contempt, showing the court all the things that mom is doing and not following the court's order.
Understood. Guess I'll be seeing you all later this week or next week.
Okay. Anybody else? Okay, so I'm going to close at this point. It's a lot of fluffy stuff now. So the resources and next steps. I know I talk fast. I'm from the Caribbean. I can't help it. So, and I was trying to speed through this so y'all had more time. Hopefully y'all got some information from what I was talking about. We are here for consultations. We have at our firms, we have a non-attorney consultation that's a little bit cheaper. And then we have an attorney consultation. And we also have what's called a strategy session, which is a little bit more expensive, where we actually give strategy, we review documents for you. So all these options are available. We can only help you if you call us, if you reach out to us. So our office number is 404-494-0027. Our website is www.southatlantafamilylaw.com. We're here Monday through Friday. We answer our phones from 9 to 5, but we do have an answering service that answers after hours. We are trying to now maybe put in some Saturday consultation times, but we're not there yet. We're working on it.